Yes, my lord. My lord, the plaint case,
Please, defendant number 1.
defendant number 1 is, my lord, the bank with whom, my lord, the plaintiff number 1 had a bank account. Now, my lord, in terms of what has been pleaded in the plaint, the plaintiff number 2 had a phone number which was for which the service provider was Vodafone. That particular phone number was used as the registered mobile number of the plaintiff number 1 for operations of its bank accounts maintained with the defendant number 1. On the fateful day of 26th of October 2016, for a period of around 1 hour, the plaintiff number 2's phone number was non-operational for about 1 hour because, my lord, there was a request made to the telephone service provider for issuance of a duplicate SIM. During that period, my lord, which the plaintiff states that he came to know of subsequently around November 6 or something, sometime around that, I'll just give the date, my lord. They found that there have been 5 separate transactions by which about 34 lakhs from the bank account of the plaintiff number 1 maintained with the defendant number 1 bank has been withdrawn unauthorizedly. Now he has pleaded the names of the 5 persons to whose accounts these transactions have been credited. And, my lord, the pleadings are such, my lord, that the plaintiff alleges that in collusion and in connivance with each other, the defendants have permitted these transactions to occur, as a result of which there has been deprivation of funds of the plaintiffs to the extent of 34 odd lakhs. Claim is on that account for breach and negligence and, my lord, recovery of the sums. Now, my lord, if your lordship is pleased
Let me check couple of things first.
Yes,
Issues देखो ना तो issues हो चुके हैं.
issues are there. We took out that order. It appears.
Defendant number 1 filed WS,
Everybody's filed WS.
but now not appearing for arguing.
For the time being, she's not here, my lord. The counsel was there. She's cross-examined even the defendant number 2's witness. My lord, by an order of 13th of January 2023, the issues have been framed.
Any limitation issues there?
Yes, my lord, there is one issue with regards to the maintainability of the suit.
That includes limitation.
Yes, my lord. I'm sorry, my lord, that issue somehow, no, that issue is not there.
WS টা দেখি. One issue on maintainability should be there,
Yes, my lord.
including
In fact,
limitation.
yes, my lord, because I think it was my oversight. Because, my lord, it is my specific case in my written statement that the suit is not maintainable before this honorable court.
First is maintainability issue. Secondly, another plea is raised, non-joinder,
Yes, my lord.
misjoinder.
Yes, my lord. Misjoinder of parties as well as non-joinder of necessary party. These are two separate issues, my lord.
So one point is taken that there is no privity of contract between plaintiff
Yes.
number 1
And the defendant number 2.
and the defendant number 2.
Because, my lord, the telephone service provider is, and the registered customer for the defendant number 2 is the plaintiff number 2.
Let me recast the issues.
My lord, that your lordship may, my lord, in terms of Order 14, Rule 5. My lord.
Yes. All right, I'll go through it.
Very well.
Check it. Have you any? Do you like to file any other suggested issues or like that?
I can bring.
Because issues should be more general in nature.
Yes, my lord. If your lordship directs, my lord, I'll come back.
I'm not directing you.
I may file.
Let me frame the issues. If you think something is to be added or changed, I will do that.
Lordship. Very well.
Hard in part. আচ্ছা ওটা ছেড়ে দাও, ওটা আমি চেম্বারে ডিকটেশন দিয়ে দেবো। এটা চেম্বারে দিয়ে দেবে। এই দুটো রিটেন স্টেটমেন্ট, একটা প্লেন্ট আর ইস্যুগুলো।
Well, the matter is kept on.
When will you be able to come?
Well, any day convenient to your lordship.
The 31st January is okay?
Lordship. Grateful.
First over matter, item number 2, commercial division.
I'm for the defendant number 2. My arguments are pending. I have already completed my factual part. Your lordship will remember this is a claim against an insurance company. I am the agent of the insurance company. I have also been impleaded because the according
ইস্যুস গুলো দেখি একবার। Are you sure issues were framed?
yes.
Because in some cases I found at the time of writing judgment there is no issue.
No, issues have been framed.
In fact, issues are juxtaposed. 6 should come at the below.
Yes, that is that.
Maintainability issue should come at first.
That can be, madam.
Did you take any limitation issue?
No.
Cause of action?
No. My point was very simple. I said there is no cause of action against me.
Apart from this, cause of action issue is there.
Yes.
You take the double study. So that should be included.
Question is whether I can be liable.
Definitely.
Yes.
But whether the cause of action, these issues have you raised in the written statement?
Yes.
Yes, you raised cause of action.
Yes. Absolutely.
So that must be an issue.
Yes, but I think it was covered in that issue where they have said it is I am jointly and severally liable.
I will reframe the issues.
Yes. But anyways, I have almost concluded. I only had to cite the judgment. Your lordship will remember on the last occasion, I had argued that in view of the admitted position that I was the agent of undisclosed principal, no liability or claim under the insurance policy I could be made liable for. To this end, I had cited section 230 of the Contract Act. But I'll just play section 230 once and I have 3 judgments to cite.
Phone number.
এখানে দেখে যাও।
Your lordship has found it. Section 230. agent cannot personally enforce nor be bound by contracts on behalf of principal. In the absence of any contract to that effect, an agent cannot personally enforce contract entered into by him on behalf of his principal, nor is he personally bound by them. Presumption of contract to the contrary. Such a contract shall be presumed to exist in the following cases: where the contract is made by an agent for the sale or purchase of goods for a merchant resident abroad, where the agent does not disclose the name of his principal, where the principal, though disclosed, cannot be sued. I don't fall within any of the three.
There is a Supreme Court judgment, Vivek Automobiles.
Yes, Vivek Automobiles, there are others, my lord. I'll cite Vivek Automobiles, but let me start with Vivek Automobiles in that case. Kindly see, this is reported in 2009, volume 17, Supreme Court cases 657. I'll kindly straight away come to paragraph 2.
You have given me 2 copies.
I'm so sorry.
Paragraph
2 onwards. It's a very short judgment. It appears that the MRTP Commission in this case has proceeded on the basis that the appellant had not filed any answer to the notice and an order was passed holding the appellant together with the respondent number 2 liable to refund an amount of rupees so and so with interest at the rate of 12% per annum to respondent. Earlier part of the order of the commission itself records that the appellant had in fact filed a reply to the notice. In the circumstances, the appeals are allowed.
para 8.
Yes, para 8 is just the conclusion. Section 230 of the Contract Act categorically makes it clear that an agent is not liable for the acts of a disclosed principal, subject to a contract to the contrary. No such contract to the contrary has been pleaded. An identical issue was considered by this court in Marine Container Services South Private Limited versus Gogo Garments, where a similar order passed under the Consumer Protection Act was set aside by this court. It was held that by virtue of Section 230, the agent could not be sued when the principal had been disclosed. Now, Malad, that Judge Vivek Automobiles.
You are defendant number 1.
I am defendant number 2, Malad. I am the bank. But kindly also
Come with
see,
the compilation. All these judgments come with the compilation. Let me see it. See this judgment.
I will annex the judgments to my note. Yes. Section 2009 16 SCC 274 on the same point, Malad. Paragraph 7. Then there is, Malad, Marine Container, which is the mother judgment, that is 1998 3 SCC 247.
That is mentioned in Vivek.
Vivek. 47. Here your lordship will kindly take paragraph 5. Paragraph 5.
All right.
Those are my submissions, my lord. I say that because the bank was an agent of a disclosed principal, the defendant number 1, no liability can attach to the bank on the basis of a claim on an insurance policy. Case is not that the plaintiff had been fraudulently induced to procure the policy. Case is policy was good. Claim made under the policy was for rupees X. They got a fraction. So they are suing for the balance. Now, it can't be made liable for the balance clearly in light of Section 230. So as against the claim against me is concerned, Section 230 is a complete answer. Those are my submissions, but I'll put in a written note.
I will recast the issues.
Yes. It doesn't really, because against me, the only material issue so far as I am concerned is whether I can be liable.
Whether there is any breach of duty.
Yes.
Breach of service, breach of duty.
No, but again, so far as I am concerned, breach of service, breach of duty, everything will come from the policy. It's a claim under a simpliciter, claim under an insurance policy.
Issue will be that.
Yes.
Now that issue will be decided whether you are liable, whether you are not. These things be,
Yes.
And secondly, maintainability issues, cause of actions issues are not there. There should be specific things like that. এটা চেম্বারে দিয়ে দেবে, আমি অর্ডার করে দেবো। Which day do you prefer?
I am done. So it is now for the defendant number 1.
For the plaintiff, I'm appearing. I was not present, I'm sorry, but I am told by my learned friend that
You are
your
plaintiff,
lordship-
defendant number 1.
No, I'm for the plaintiff in
Who is
the
defendant number 1?
I'm for the defendant number 1.
So you must argue next day.
Yes, Your Lordship.
When will you come?
Your Lordship, I have been told between 10th to 14th February, if it's
So long date.
between any date, 10th February, Your Lordship. On next week, he is not available, Your
Are
Lordship.
in
I'm
part
led by-
on prayer of the learned counsel for defendant number 1. Between 14,
10th to 14th, any day, 10th February also, Your Lordship. He shall be there.
11 February.
Grateful, Your Lordship.
My lord, so far as recasting of issues are concerned,
এইটাতে না আমাকে একটু চেম্বারে আসবে আমি দিয়ে দেবো।
my lord, will it be your lordship's pleasure to hear out the plaintiff on the submission so far made because prior
No,
to
first thing is that
Yes.
certain issues are raised in the written statement, like the suit does not disclose the cause of action,
Yes, those may be
limitations. So
yes,
these should come.
come. Yes.
Maintainability issues,
I do
this
not
should come.
stand in
And
the way, but-
secondly, so many factual details are there in the issue. This should be more generalized.
My lord, that I follow, but so far as this, the judgments which have been cited with regard to the principle of law, could we come back on the next day and
Next day, she will argue.
no,
When your
just
turn will
limited-
come, you will argue.
just limited to the point. Is this on merit you are submitting or it's only for the, may I just make?
He has completed
well
his
then.
argument.
Very good.
Then next argument will be made
Yes,
by
the
Ms.
defendant
Laha,
number 1,
and then finally
thereafter
we'll make a submission.
we'll make the submission after the
Yes,
yes
in the
very
proper
good.
order.
Yes, in the
When your turn will come, you may argue.
very
Grateful, Your
এই দুটো আমাকে চেম্বারে দিয়ে দেবে, আমি অর্ডার করে দেবো এখানে।
Regular list, item number 1.
That this matter, my lord, decree has been passed, my lord, by your lordship. The mean profit, my lord, has to be ascertained, for which, my lord, is kept today. Now, my lord, my humble submission, my lord, no referee is required, my lord. Your lordship can do it because I have given, my lord, comparative 4 lease deeds. In the same building, my lord, the rate in 2009 was 65. So I'll leave it to
Let
your
there be evidence, let a commissioner be appointed.
My lord,
Or I will,
my lord, I'm for the defendant, my lord. Today, my lord, inadvertently, my lord, GA 2286, my lord, has come, my lord, in the list, my lord. But which is, my lord,
GF4 of 2005, why it has come?
that is, my lord, some inadvertent, my lord.
देखिए
Error.
judgment দেখি লাস্টে বলা নেই, along with that. No,
My
the
lord,
judgment.
my lord, judgment records that all applications, my lord, are disposed of.
Will be a protracted, my lord. Everything is here before your lordship. Nothing, no more evidence is required to be led also. And the man is, my lord, already in his 80s. He will probably, my lord, die in the meantime, my lord, while.
What do you have to say?
My lord, the referee may be, my lord.
Uh-huh.
My lord, the referee may be, my lord, a commissioner may be, my lord.
The property.
My lord, my lord, the 4 lease deed, my lord, they have, my lord, adduced, my lord, in evidence, my lord. We have, my lord, raised an objection to that effect, my lord.
That was why.
That was, my lord, turned down, my lord. Thereafter, my lord, we preferred an
So I'm fixing another date of hearing, I will fix it.
My lord. And my lord, kindly record, my lord, that 226 has been disposed of, my lord.
GF4 of 2005 should be treated as a disposed of, since the suit was disposed of in terms of the judgment. Now, ওই লেখা তো GA4 of 2005, দেখি একটু কি আছে, that is for mean profit.
No, my lord, this is, my lord, an interlocutory application, my lord, in the suit, my lord.
Stands disposed of, should not come in the list. Full stop. Today is fixed for consideration of mean profit. The learned counsel for the plaintiff submitted that no special referee need to be appointed. Fix. টোয়েন্টি-4 কি আছে দেখো, কতগুলো আছে? 24, 27, next. 24 is okay for you? 24? 24th January for hearing on mean profit.
My junior has problem.
My lord, next week, my lord.
Next week, any date?
Any day, I'll come.
বলো তো। 7 February is okay?
Yeah, then your lordship will keep it 20, 24. If not 27th or 20.
27 হবে
28.
27
I'll come up with a one pager just to bring it to your lordship's notice the.
you are also at liberty. Parties are at liberty to file their respective written submissions
On min profit.
on the point of min profit. Obviously, suit is not living anymore.
I don't know whether they'll come up with everything.
Definitely, they will go.
They-
Item number 2.
Corrections. What corrections are to be made?
Remember, Mr. Siddharth today is appearing for the defendant number 1. In the matter, your lordship remember in connection
What corrections are to be made?
put fee 50,000 the plaintiff has paid, and only that share and at 33,300.
Do one thing, make corrections in the order. Which order is to be corrected?
That is ordered.
Make correction with pencil, submit them, I will check it.
Item number 3.
Day has come. The day has come.
So some order is to be corrected, make corrections with pencil and submit them. I will check it.
That I am telling my.
Much obliged, Your Lordship.
Item number 3.
Your Lordship, I am for the defendant number 3. I am opposing the restoration application.
GA3 is restoration application.
My lord.
For the plaintiff, the counsel engaged in this matter, my lord, is currently out station for a week and seeking accommodation for a week.
On prayer of the learned counsel for the your plaintiff. Plaintiff. Hearing is adjourned to 28th February.
20, my lord. 20.
Item 4. Regular list.
Not
Item number
20th February. 24th February.
As your lordship.
I'm appearing for the defendant respondent in this matter.
Hmm.
My lord, on the last occasion on 25th October, my lord had directed us to file the affidavit in opposition and the affidavit in reply.
What is
My-
GA7?
GA7 is their application for judgment upon admission. Well, I am out of time in filing the affidavit in opposition. I am seeking the 3-4 days time to have it affirmed, my lord.
Time is extended to file affidavit in opposition till the returnable date.
It was returnable on.
Your lordship, we would also like to file a reply there.
Affidavit in opposition shall be filed within 2 weeks. Affidavit in reply, if any, within 1 week within 2 weeks thereafter. The matter will appear in the list on 3rd March.
Great.
Item number 5.
I am appearing on behalf of the by your lordship order dated 21st November. And a direction was given to my learned friend to file affidavit in opposition against.
What is GA4?
GA4 is my lord, my application for occupational charges. So they have
Exchange of affidavit is complete.
No, the direction was there to file affidavit in opposition within 3 weeks. But they have served a copy of this application affirmed on 17 January, served me on Saturday. So my lord, time to file.
But kindly condones the delay.
Affidavit in opposition is filed today. Let the same be kept in record. Time for affidavit reply is extended till 7th February.
Not one humble indulgence, minute. If your lordship kindly permits our application under Order 7 Rule 11 to be taken up on that day.
What is the
give the
number of application?
But
My lord,
there has been
the direction was there, my lord. GA4 will be appear along with other
other
applications.
applications. It has already
That
been there.
direction was there, my lord.
So maybe if that could appear.
Order 7 Rule 11 is GA4.
No, this is GA4. The other one of the other applications pending is Order 7 Rule 11. I shall give the number.
All the applications, pending applications shall appear in the list on that date.
I'm grateful.
Much
Order 7 Rule 11 exchange of affidavit is complete.
My lord,
Yes.
my lord.
I'm so grateful.
This is for GA4 is for?
For enhancement of the occupation charges.
Okay.
Much. My lord, matter affidavit in reply for 7th February and matter will be appear. My lord.
7th February means 7th February. This matter along with this application, along with other pending applications shall appear in the list on 7th February.
Item number 6.
But I appear for the defendant.
What is J6?
Well, it's my application for rejection of the plaint and or
Please
return.
go other side.
Well, they had appeared on the last occasion. In fact, well, directions for filing of affidavits were granted. However, it's not gone down in the order.
None appears for the plaintiff. Although the learned counsel for the defendant is present. Exchange of affidavit are yet to be done.
My lord, there was a direction. That is not reflected from the order. Lordship will kindly direct, my lord.
Affidavit in opposition shall be filed within 2 weeks. Affidavit in reply, if any, within 2 weeks thereafter. The suit will appear in the list. 24th February.
Lordship.
Item 7. Item number 7.
Defendant number 2 here, my lord.
Heard extensively.
Yes, my lord. They were in reply, my lord, and we have to give our rejoinder arguments.
There were directions upon them to disclose the legal heirs of one of the defendant who had explained, also defendant number 4. They had given us the
Have you filed any application? Use microphone.
The legal heirs are, your lordship, already on record, your lordship. Let the death of defendant number 4 be
File application. How can I know? Defendant number 4 expired or not? File application with death certificate.
Last order records that they are supposed to file a substitution application.
But the legal heirs were already there on track.
File an application.
Lordship,
How can I know?
Come to know on the basis of newspaper public, if the death certificate can be provided by them.
Either they will provide or I can call for death certificate. That is no issue. But file application. Substitution application is yet to be filed. Full stop and accommodation is sought for. Adjourned to 4th March.
Item 8.
I appear for the defendant number 1. Well,
What is J6?
well, this is my application, plaintiff's application seeking transfer of the suit from the regular division to the commercial division. And a consequential amendment pursuant to that transfer if lordship allows the application. Kindly sees the reliefs in the suit which I had claimed. It is a suit for specific performance. Paragraph 2 of my application, the reliefs in the plaint have been quoted. Now the actual property is being used for trade and commerce. I have stated that in paragraph.
Exchange of affidavit is complete.
Yes, my lord. Only one of the defendants chose to file affidavit. It is the defendant number 1. Twofold objection has been taken in the affidavit. One is delay. The plaint is also annexed with my application with the proposed amendments in it. My lord, if lordship kindly comes to page 9, my lord, I have disclosed.
Let me go through this.
My lord.
How it's a commercial agreement?
My lord, kindly comes to my lord, page, my lord, 4 of my application at para 6, my lord.
No,
And I
it
will
is
show
it
from
is
the
not
written
it
statement
is
of
not whether what your application says, but what the plaint says, that is more important.
I will show from the plaint as well as the admission in the written statement. My lord, the written statement also admits that it is used for commercial purpose.
Who
Kindly
use
come
for commercial purpose? Tenants.
tenants.
That is not the agreement between tenants and the tenants are not party to the agreement, proposed agreement.
Property is being actually occupied by
That is
tenants.
a question of
The-
fact.
No, the agreement, my lord, that's not disputed here. May I show only one paragraph from the written statement because Lordship will, my lord, get a picture what is the admitted position. My lord, kindly takes the written statement of the defendant number 1. Page 21, my lord, kindly comes. Written statement of the defendant number 1. My lord, at the top, my lord, third line. It is stated that the ground floor of the premises was entirely occupied by several tenants and occupants.
That is not enough. That's a question of fact to be decided. This question shall remain open. At this stage, it cannot be said it's a commercial dispute.
No, my lord, the agreement is in respect of a property, my lord, with a, my lord, old 3-storied building.
Yes.
This agreement, this property
Some of the
was being
tenants are
occupied.
carrying on commercial activities.
So, my lord, if the property is actually being used for trade
Who
or
are using
commerce,
this?
my lord, these occupants who are using it,
That is not a question to be decided here. If the some of the occupants are using it for commercial purpose, that is not subject matter of the suit.
my lord, the subject matter
Sorry.
is no, my lord. I'll just, my lord, try and explain, my lord. The subject
Sorry,
matter
if
is
the
an agreement.
tenants and unauthorized occupiers who are using it for commercial purpose or not, that's a question of fact. Parties have not entered into transaction in course of business deal.
No, but if
Deeply
the, my lord,
obliged.
agreement is in respect, my lord, the subject matter of the, my lord, agreement
The
is in
question, I'm not
respect of a
foreclosing the question, whether it's a commercial dispute or not. But prima facie, the plaintiff does not disclose that it's a commercial dispute.
The only
Deeply obliged.
difficulty would be this, my lord, that then I have, if we proceed in the regular division, the, my lord, modalities of trial would be different. And if ultimately Lordship comes to the conclusion, no, this is a commercial dispute, we cannot put
Prima
the clock
facie, it's an agreement, it's a suit for breach of contract or specific performance of
specific
contract.
performance of a contract.
Neither of this agreement, neither of the parties entered into or executed this agreement in course of trade or business.
My lord, but
Some, yes, your point is some of the traders or some of the occupants are carrying on business.
my lord, may I just have, my lord, 2 minutes? I just want to, my lord, put this and thereafter whatever Lordship decides. My lord, the judgment in Ambalal Sarabhai's case passed by the Supreme Court said that if a property is actually being used for trade or commerce, then, my lord, commercial court's jurisdiction
I agree.
gets. So, my lord, my case here is for specific performance of an agreement. Agreement is in respect of a property. Property is actually being used for trade or commerce. So, my lord, whether the agreement envisages anything or whether the parties are in business transaction or not is
Instant
not the, my lord.
application. That is J.
6, my lord.
এখানে লেখা নেই কেন গো J6? CS60 আছে। J6 of 2024 is filed by the plaintiff, your defendant.
I am the plaintiff.
Defendant number 1.
So, I am the plaintiff, my lord.
You are plaintiff.
Yes, my lord. I am saying, my lord, it's a commercial dispute. It should be transferred to the commercial division. And written statement they have admitted, my lord, it's a commercial activities are going on, my lord. They have not really opposed.
আচ্ছা আমি এটা কোর্ট চেম্বারে দেবো আই উইল পাস দিস অর্ডার ইন দ্য চেম্বার
Your Lordship would
আই ক্যানট
also,
এগ্রি উইথ ইউর সাবমিশন
my lord, your Lordship may kindly hear me, my lord. I am the defendant number 1 opposing the application. My lord, from paragraph, if your Lordship will kindly take one paragraph of the, my lord, application filed by my learned friend, it would be clear. It is admitted that at the time of institution of the suit, the plaintiff was not aware about the existence of tenancies and the fact that the property is actually used for trade and commerce when the suit was instituted. So admittedly, my lord, as it has fallen from your Lordship, my lord, the plaintiff does not say that it is used for trade and commerce. It is only in the
some of the tenants are carrying on trade and business. That's a separate issue.
That is a separate
That
issue.
is not subject matter of the
my
suit.
lord, my lord, deeply obliged.
Yes, next matter. আমি এটা চেম্বারে দেবে আমি অর্ডার করে দেবো
Consider section 2171, my lord, in
I have seen, I understand this.
Only one. I appear for the defendant number 2. But issues were framed on 29th of September 2020.
Let this be disposed of. Issues are framed, now it will be for witness action.
Witness action has to commence because one of the plaintiff is enjoying an interim order since 2017.
appeals were preferred from that order.
Yes,
Appeals
so you
have
are
been
enjoying
dismissed.
an interim
We
order,
could, my
but
lord,
let the
complete,
plaintiff
my lord, what
commence.
is the present?
All right.
Plaintiff take steps in terms of the suit.
Next matter.
Item number 9.
I'm for the plaintiff. Well, in my suit, I'm faced with a demurrer. 711 on the point that is a suit for land. That's a 711 application, my lord. It's been pending since September 2023. It's ready. And the defendant has been taking adjournments and not moving the application.
Instructions from the client, Lordship. The difficulty is that the main defendant had passed away and the substituted defendants, Lordship, we are unable to communicate.
Whose application is this?
Lordship, our application.
It will be dismissed.
Lordship, Lordship kindly gives me one last opportunity. Substituted defendant is, Lordship, hospitalized. Your Lordship,
Lord, your Lordship will see from September 1st, 2023, it's been lying ready for hearing. And every time they come and take an adjournment or something.
Settlement, on the ground of settlement.
Every time they come and say this, there's no settlement at all. And every time they come and we get confused because say it with so much confidence in court that talks of settlement, we have to go and take instruction.
Learned counsel for the plaintiff. 6 for an adjournment. Full stop.
No, I'm the plaintiff. I don't.
Defendant. 6 for an adjournment. Full stop. The learned counsel for the defendant strongly oppose the application, strongly oppose the plea of adjournment on the ground that matter has been dragged for long. Full stop. Fix 27 January for hearing of the application. No adjournment, further adjournment shall be allowed.
Well, the only thing is the last bit will be plaintiff opposes the adjournment. Counsel for the plaintiff vehemently opposes.
Yes, opposes the objection.
Grateful.
Item number 10.
What is J5?
I'm for the plaintiff, my lord. I'm for the plaintiff, my lord. They had filed an application, my lord, for amendment of written statement. My lord, there was a direction for opposition, your lordship. It is ready, my lord. It could not be affirmed since the deponent is unwell.
On prayer of the learned counsel for
2 days extension.
You are for?
I'm for the plaintiff respondent.
Plaintiff time to file affidavit in opposition is extended till the returnable date. The matter will appear in the list on 28th January.
28th.
Sorry. Yes, 28th January.
28th.
28.
Great.
Item 11 and 12.
ওইটা আগে অর্ডার করলাম না 11টাও J4
Item number 11 and 12.
None appears. Adjourn to 4th March. 4th March. Come on 4th March.
Okay. But I was only praying when this is my suit. But a defendant has taken out this application, but which can be heard by your lordship.
Who is for the defendant?
But
What is GA4?
I'm forgetting GA4 is my application for transfer of the suit to the commercial division because it arises out of carriage of goods.
None appears for the defendant. Although the learned counsel for the plaintiff is present, adjourned to 24th January.
Grateful, my lord.
13 and 14.
Lord, I appear on behalf of the defendant in the suit. My lord, in terms of your lordship's.
Should it be commercial?
My lord, in this matter, lordship had passed an order on 20th December 2024 permitting, my lord, the Phoenix ARC to step into the shoes of the plaintiff. My lord, because there is a settlement which is to be arrived at between Phoenix ARC and the defendant, lordship had given leave to my learned friends to, my lord, take steps in that regard. My lord, I'm told that that has not happened because, my lord,
and the question is whether it's a commercial dispute or not.
My lord, now the matter is going to get settled. My lord, it is settled.
Past a restructuring plan, your lordship, where it is getting.
So should just to adjourn the matter.
My lord, only for my learned friends to
take the leave, your lordship, to file the wakalatnama because the erstwhile.
Leave is granted to file wakalatnama.
So that we can amend the.
Things are settled.
Your lordship, so that we can amend the memo of parties, your lordship. Because unless it is done, the settlement cannot come in the picture, your lordship.
My lord, on the next date, my lord can keep it for withdrawal because my learned friends will withdraw the suit in view of the settlement.
Adjourn to 29 January.
Obliged.
Item 15.
I'm appearing for the dictionary.
Parted matter.
Yes, my lord. We have also filed our note.
I heard Mr. Chaudhary.
So your lordship may fix any date, my lord, for hearing of this.
March. Adjourn to 3rd March.
No, my lord.
On the last occasion, we have filed our notes.
Yeah, but you have not yet made your submissions completed. Make your submissions.
Item 16, 17 and 18.
Last order ki chalo dekhi. You are also looking for the last order.
Yes. So the last order your lordship had directed them to file affidavits in respect of my application for setting aside the sale of the Ghatshila property. And remember that story?
Yes. Have you filed affidavit? Who is the defendant?
Yes, they have filed affidavit, and guess what they have filed? That's why I said, remember the story of the
Affidavit. Who will file affidavit?
The purchaser who brought the property. They have filed the affidavit.
None appears for the bona fide purchaser.
Same affidavit they filed in 2013.
On 11 December, opportunity was given to file affidavit in opposition as well as reply.
They have served on me.
They have filed it or not?
Yes, filed. Same affidavit.
That is not the question. Question is whether they have filed AO or not.
They have served me with an affidavit which is already on the record from 2013. The same affidavit, they have again filed it.
I have given them direction to file AO.
Yes.
Whether pursuant to this any AO is filed or not.
They have filed, not new.
Kothay? That is separate issue. Content is a different issue. Whether this order is complied with or not.
No, they have served on me.
11 December. 11 December order দেওয়া হয়েছিল AO ফাইল করার জন্য। কি বললাম অর্ডারটা? Full stop.
On 11 December 2024.
Full stop. তারপরে on 11 December 2024.
Opportunity was given to file affidavit in opposition as well as
affidavit in reply. Fixed 21st February for hearing of GA. This is GA?
This is GA 11781 of 2013, which is Yes. 17.
No, 49.
1817 of 2013.
49 of 13.
49 of, yes, 49.
For GA 49 of 2013. The council shall exchange affidavit in the meantime.
Lord, may I just
a minute. In case affidavit in opposition is not filed in the meantime, it will be deemed that there is nothing to object against affidavit against GA 49 of 2013.
Lord, may I just clarify? Your Lordship heard the matter. We submitted written notes of argument.
Yes, we have done this. I can remember still.
Now, this affidavit which they have served on us, this is on record. They have already filed it in 2013.
Very good.
Before your Lordship. Again, they have now come and
Very
served
good.
this.
Now the question is, I have passed an order, whether they have complied with or not, whether they have availed of that opportunity. Rather, it's better to say they have not. So I will heard it ex parte. Since it is not on record, there is no scope of considering this. And on the next date, if AOD is not filed, it will be deemed they have nothing to object. Only an opportunity should be given before hearing or passing any order.
25th. I think there's one more application for the there's one more
Bhuvajya property.
Yes, that they have advertised. The difficulty is to be honest, some local buyers, they have heard the news of this sale and they have come forward, but nothing has sort of been finalized yet. So Lordship will keep adjourn the matter. In the meantime, someone comes
on the same date. All the applications will appear in the list on the returnable date.
That's 25th February.
Tell me whether any development took place.
That yes, some have come forward, but the difficulty is only one.
Receivers have not received any offers pursuant to the advertising made by the receiver.
There is something what is happening with due respect to the receivers as well. Apart from the original tenants and the list of tenants submitted by the receivers, we now see that there have been many encroachments in the property. Difficulty is this of selling out is because the entrance, there are two entrances.
Granted receiver
locked.
Shall submit a report.
And there is a temple which has been built inside.
The physical status of the property, including the names of the occupiers and their details.
Some constructions have been made.
Physical status of the property, that includes all.
And that is why it's difficult to get into the property.
All right, let the report come.
Because some of the intending purchasers, they have visited the site.
And they'll be obstructed, obviously.
Oh, no. They're facing difficulty in getting access to the property.
All right, let the report come. I will pass the necessary instruction.
Should we kindly direct the applicants to assist us to locate, because we have seen that. An advocate's chamber
It goes without saying. This is the applicant's interest. You are working in the applicant's interest. So if there is any opposition, there is any non-cooperation, you come and mention that.
If we go, there's nobody to assist us to locate.
So the local Thana can assist.
Do one thing. Go there, prepare a report. If you are resisted, then come with a report soliciting instruction that I went there, I could not complete the job, pass the necessary direction.
Myself and Mr. Ananda Ghosh is the
all right. Solicit necessary instruction, I will pass it.
This is the difficulty because purchases are going.
Let something come before this court.
That is why I mentioned it today.
Item number 19.
Number 19, my lord, I am for the plaintiff lordship.
Who is the defendant? What is the status of the suit?
Last time, lordship, I am praying for not today.
Not today, not this week.
তুমি যখন বলবে বলে দেবে আমরা করে দিই।
Item number 20 to 26.
Lordship,
I pray for the plaintiff lordship.
Lordship, in this matter, I beg to appear on behalf of the Shevites.
Lordship, I'm for the defendants here. We've gone in for an.
Yes, what do you have to say?
Perhaps the appeal has been preferred by the defendants.
Is there any appeal
Yes,
pending?
Your Lordship.
Yes, and the appeal is pending, Your Lordship.
Lordship, only item number 26, it is uncontested.
26, I have not taken up. Oh, yes, 26 is there.
Yes, yes, Lordship. And the chief has.
Since the appeal is pending, I should not hear it right now.
Yes, Your Lordship, seeking for an adjournment till.
In view of pendency of the appeal,
Lordship, in 26, there is no appeal pending.
there may be a related issues. One cannot be decided without the other. Let the appeal be disposed of. In view of pendency of the appeal,
It is
all the applications are
Lordship.
deferred to 10th March.
Lordship, I appear on behalf of some of the Shebaites.
All
That is the descendant of the original Shebaite. Grateful.
27.
Lordship, may I be permitted to take one submission? In 26, it is uncontested, and the chief has already been concluded, Lordship. May I be?
All the matters are taken up together.
Okay.
So one may be related to the other. One judgment or decision or consideration of one matter may be affected by the appeal. So we cannot pass that. We should not pass any order. All the matters.
Grateful.
27.
I am for the plaintiff. Well, last occasion, there was a direction for discovery and inspection.
Lordship, I have provided my name in the chat box.
নামগুলো দিয়ে দেবে.
We have already disclosed the documents to the.
Who is your other side? You are plaintiff.
Yes, I am for the plaintiff.
Who is the defendant? Time was extended.
Yes, time was extended. Lordship, I have already supplied them the documents for inspection.
None appears for the defendant. The learned counsel for the plaintiff submitted that all the documents were produced for inspection and discovery. All the documents were subject to discovery and were subjected to discovery and inspections.
Lordship will kindly extend the time so that they
Let
can.
the suit appear in the list for framing of issues on 4th March. On 3rd March.
In the meantime, if they intends to.
Discoveries, inspections, disclosure of documents may be complete between the parties in the meantime.
Great.
28.
Lord, I appear on behalf of the plaintiff in this suit. My Lord, on the last occasion, Lordship had disposed of one of the GAs, which is GA 10 of 2024. My Lord, the two GAs which are pending consideration before your Lordship is one of my application, which is for payment of occupation charges. My Lord, in that, my Lord, pleadings are complete. Lord, I don't see my learned friends here, but my Lord, I do not want to proceed ex parte. It won't be fair on my part, but kindly.
None
make
appears
this
for the
peremptory.
defendant.
Lord, yes, my Lord.
Defendant. None appears. Are you here? None appears for the defendant. Although the learned counsel for the plaintiff is present, adjourned to 5th March.
Lord, kindly makes it peremptory, my Lord. Lord,
no further time will be allowed.
I am very grateful to your Lordship.
29.
You are plaintiff or defendant?
The defendant in this matter.
For the plaintiff in this matter, Lordship, there was
Suggested issues are there. Discoveries
inspection is yet not complete.
Discoveries and inspection are yet to be complete. Adjourned to 3rd March. Discoveries and inspection shall be complete in the meantime.
Grateful to
The
Lordship.
suit shall appear in the list under heading for framing of issues.
Great. 3rd March.
এই দুটো পাঠিয়ে দাও। তিনটে পাঠিয়ে দাও।
For arguments, item number 30.
Lordship, I'm appearing for the plaintiff. The defendant was supposed to commence their arguments with respect to the preliminary issue of mentioning.
You are for? You are for?
The defendant.
You are for plaintiff.
Plaintiff.
Who will start argument?
So the defendant.
We will start argument, my lord. But before that, my lord, this is a suit for specific performance of a lease deed, which is not sufficiently stamped. It has been tendered and exhibited, subject to objection. Even if there is no objection, my lord, it cannot go through. Now, first it has to be impounded because, my lord, I will have to refer to this document, but this document cannot be looked into and it is their exhibit. But the first order of business has to be to impound this document, my lord.
You submit your argument first.
My lord.
For impounding, you have to file application.
My lord.
Now, law is very well settled.
But Sonu versus State of Haryana and then Justice.
That is separate issue. Sonu versus State of, this is unstamped. You say unstamped.
Inadequately stamped.
Inadequately. Sonu is not applicable here because of very specific statutory provision. Once it is admitted, then it's all.
Yes, Lord.
No, my lord, it has not been admitted. It was
have to file application.
Yes, I have
for
to
hearing
take out
this,
an
or
application.
I will hear the argument. At the time of final disposal of the suit, I will comment on the issue.
Very well. Very well. We'll take out an application, but I'll start my.
Better you continue the argument.
My lord.
If according to you it is insufficiently stamped and cannot be relied upon, then the merit of the suit will be affected accordingly.
My lord. My lord. My lord, the issue, the preliminary issue which falls for determination now before my lord is whether this suit would be barred by sections 34 and section 35 of the Surfacy Act. What is the plain? I'll go through the plain, my lord. I'll give a brief overview before that. What is the case which has been set up in the plaint? Bharat Chamber of Commerce was the owner of a piece of land. The bank, which is the defendant before my lord.
Who is Frontline Corporation?
My lord, the plaintiff. Plaintiff purchased it from Bharat Chamber of Commerce. My lord, the defendant since 1973 was a tenant in respect of
defendant means
my lord,
Punjab
and Sindh Bank was a tenant in respect of this property. In 1993, a suit was filed by the bank that is not relevant. And in 2003, Bharat Chamber of Commerce filed a suit for ejectment of Punjab and Sindh Bank. During the pendency of this suit in 2005, the plaintiff purchased this property from Bharat Chamber of Commerce. The plaintiff also independently during 2004, 5 and 6 obtained certain credit facilities from Punjab and Sindh Bank. Around 2010, the plaintiff put in a proposal that they wanted to construct a new building, demolish the existing structures and construct the new building at that site. And for that, they wanted the bank to vacate the land, and within 15 months, they would make a fresh construction and then he'll be reinducted as a tenant. In the meantime, what happened? The plaintiff defaulted in repayment of the facilities which it had obtained from the bank during 2004 to 2006.
No, there was a facility given to the plaintiff.
To the plaintiff.
By the bank.
By the bank.
On what is the understanding?
Outstanding.
Understanding.
That is, my lord, a separate credit facility, my lord, where they had obtained an overdraft facility of about 40 crores of rupees. And this, my lord, a separate understanding in 2010, where they would demolish the existing structures, construct a new building, and induct me as a tenant.
That is the consideration for giving over?
No. That, my lord, the loan was given against, my lord, mortgage of several properties, including the property with which, no, that is connected in the sense. The 40 crore loan was subject to, my lord, mortgages of different properties, including the property with which we are concerned. In respect of the same property, in 2010, they had a proposal that let me demolish and create a fresh structure and I'll give you. And they'll pay, my lord, the money for my shifting, etc., etc. What happened, my lord, in respect of this credit facility, they failed to pay their outstanding dues. Their account was classified as a non-performing asset. And pursuant to that, a notice under Section 13(2) of the Surfacy Act was issued. Then a possession notice under 13(4) was also issued, and bank presently is in possession of the property. This probably forms the subject matter of the suit under the provisions of the SURFACE Act. Now, challenging the 13(4) notice, my lord, they
Just a minute.
my lord.
Yes.
Now, challenging the measures taken under the SURFACE Act, they file an application under Section 17 of the SURFACE Act before the Debts Recovery Tribunal. There they fail to secure any interim relief. Thereafter, they file the suit claiming specific performance and certain other reliefs. I'll go through the reliefs. Now, the issue which emerges is whether the present suit for specific performance would be maintainable, because their contention is specific relief is not something the DRT is empowered to grant. The only recourse, therefore, would be a civil court. Our argument is, once a measure has been taken under the SURFACE Act, and I am in possession of the property under the SURFACE Act, and when your relief for specific performance entails restoration of possession from the bank to the plaintiff, it will fall under Section 17, subsection 3, and only the DRT would be empowered to restore possession, and no other court can make such directions. My lord, I'll first take, my lord, through the reliefs which they have claimed, and then, my lord, I'll take, my lord, through the orders which have been passed so far. If my lord comes to page 11 of the plaint, the first prayer, my lord, is decree for specific performance of the agreement.
Which page you are referring to?
Page 11 of the plaint.
This is plaint. Why page 11? It is page 18.
My lord, in my page 11.
No. কি করো কি? Let me go through the plaint first.
My lord.
Specific performance of the lease date.
My lord.
Mandatory injunction, so and so.
Yes, my lord. If I may just place one prayer after the other. Decree for specific performance of the agreement bind between the parties as more fully pleaded in paragraph 6 above. If my lord comes to paragraph 6 once, my lord will find it at page 3.
Number of subparagraphs are there.
Yes, subparagraph A. That the defendant would vacate the said premises and hand over possession to the plaintiff. My lord, this is a relief. I'll place the law, which can only be granted by the DRT under section 17, subsection
Is it
3.
in prayer?
My lord?
Is it in prayer?
Yes, that is what they this asks specific performance of 2 documents, and the documents speak of give me vacant possession, I will
No,
demolish.
that is in para B. Mandatory injunction directing to make over vacant and peaceful.
Yes, that is in para A, my lord. Prayer A would also entail that, but because when the
more specific in para B.
More specific in paragraph B, makeover vacant. B1, makeover vacant and peaceful possession of the entirety of the said premises to the plaintiff.
both prayer A and B can only be granted. Prayer A not in the current shape. The effect of prayer A is give me possession. A possession
more manifest in B1.
More manifest in B1. Now, B2 and B3 are really, my lord, ancillary prayers. C is also an ancillary prayer.
So first is to decide A and B1.
Yes. And then, my lord, we come to D. D, prayer D at page 12. An inquiry be made for determination of what amount, if any, is due and payable by the plaintiff to the defendant, so that the decree may be passed for realization by adjustment of so and so. Well, this is a power which only the DRT can exercise under the Recovery of Debts and Bankruptcy Act 1993, Section 19. In fact, when 1993 Act came into being, my lord, Section 31 was introduced, which provided for transfer, because my lord, previously all suits were heard by civil courts. Then, my lord, the legislator brought in 1993 Act, which directed transfer of all existing suits to the bank, where there is a question of recovery of money or what is payable.
So that's why jurisdictional issue came before.
Yes, yes. That and jurisdiction, well, it is settled under Section 18. And under Section 19, an application has to be made for adjudication of the amount.
Next day. No text.
Well, very well. And my lord, we'll only look at prayer E as well. Prayer E is also for perpetual injunction. Restraint.
Ancillaries.
All ancillaries.
First thing to decide on this issue.
Yes, yes. This is my lord has in fact entertained an application under Order 7, Rule 11. And my lord was pleased to reject the plaint on this score. They assailed the order, and the division bench Court of Appeal was of the opinion, since the trial had proceeded and evidence was almost over, let the evidence be completed and this be decided as a preliminary issue, my lord. So this is really the second round of litigation on this point. And there are orders of, in fact, in this matter from, my lord, injunction orders, there are orders of Supreme Court where it's settled, the law is settled.
Heard the learned counsel for the defendant in part. Did Bolo. February is okay?
My lord, 6 February.
6 February for further hearing.
I'm grateful, my lord.
Madam, led by Mr.
Sir, 6 February is okay?
একটু সময় ঘন্টা দুয়েক তো লাগবেই স্যার। বললেন আজকে বেয়ার একটা নেই বলে।
I have no bear act right now, so I cannot appreciate the argument.
I'm grateful, my lord.
Witness action, item number 31.
The plaintiff, my lord, I'm paying for adjournment of 10 days for 10 days.
Who is your other side?
My lord, it is an undefended suit, my lord. The plaintiff is sick, my lord, he cannot appeal.
Adjourned.
My lord, for
On
10
prayer of the learned counsel for the plaintiff, witness action is adjourned to 24th February. You are in?
32.
32, I'm for the plaintiff, my lord.
Witness action is going on.
I'm for the defendant, my lord.
You're cross-examining by possibly.
My lord, due to my personal grounds, I was praying for a little time.
You're for different plaintiff.
I'm for defendant.
Mr. Sharkar, who is the other side? He's paying for adjournment. Mr. Sharkar, the learned senior counsel for the plaintiff.
For the defendant, my lord.
For the defendant, 6 for an adjournment, 6 for an accommodation. Adjourned to 25th February.
Deep law.
Company matters, item number 33.
Lordship, Lordship, I beg to appear on behalf of the respondent number, State Bank of India, Lordship. Mr. I led by Mr.
Who is for the official liquidator? Possibly I am too early. Mr. Shah is there.
Yes, my lord, I am there. We have filed, my lord, an affidavit in opposition.
Yes.
I don't think, my lord, my friends have used any reply there too. But I don't know if they will be asking for leave to, my lord, rely upon any affidavit in reply.
I am appearing on behalf of the other ex-employee association. All along, in the VIF proceeding, they are the parties. But
That's true, but what is the application? CA number 124.
Yes, Lord.
This is an application for intervention.
No, my lord, this is not an application for intervention. CA number 124 is an application, my lord, made by the official liquidator for disbursement of money to, my lord, three entities. Number one, my lord, is the State Bank of India. Number two is the Punjab National Bank. We are the two secured creditors. And number three, my lord, is, my lord, they also want to disburse some monies, my lord, to certain group of employees. That is the only, my lord, point of objection to this application. My lord, as my lord, the two secured creditors, my lord, being State Bank
You
of
have a
India.
preferential stake.
I have a
As a
preferential
secured.
stake. I am secured, and my lord, we are the only two secured
Any
creditors.
AO file?
My lord, we have filed affidavit in opposition.
very much interested parties in the proceeding, but no.
Copy of
Lordship, this is the affidavit in opposition as it was directed on the earlier.
copy of CA 124 of 24 be served.
My lord, kindly do not direct any service on, my lord, my learned friends, without, my lord, them even filing an application for intervention. I will show to
Not
your
a party
lordship.
here right now. Then you have to
They are
file
not.
this. Then you have
They are
to
not
file
parties.
application. Unless it is so, you cannot be served.
And
Who
my
is
lord,
for the
I'll show
official
to your
liquidator?
lordship that the whole process has been held, my lord, hostage, my lord, to, my lord, completely, my lord, frivolous dues, which have been rejected, my lord, by two courts, my lord. And in spite
Let the
of that,
official liquidator appear.
Smita Dashde was appearing.
Yes. She's not here. None appears for the official liquidator. Adjourn to. Copy date, bolo.
my lord, may I be so bold as to ask for, my lord, a short date, my lord, in the matter.
February is okay?
Yes.
Shima, kindly record that we are filing our affidavit in opposition. Lordship.
Affidavit in opposition filed on behalf of
State Bank of India.
State Bank of India be kept in record.
We have served already to the official liquidator.
Your clerk is very anxious.
I apologize on his behalf, my lord.
No. Nothing to be apologized.
I'm sorry. Grateful and deeply obliged.
34. Where is official liquidator? আগে হয়ে গেছে বলে আসছে না কেউ নট টুডে করে দাও কত অর্ডার করব 35
I'm for Asset Reconstruction Company, one of the secured creditors. We are opposing the scheme.
not today
Deeply.
ওয়েল নেই আর কি করে হবে 36
The two application. But
not today making not today because possibly I have finished too early not appearing
the affidavit of service on record. It's for that application under 463 for the purpose of excuse.
affidavit of service you have filed that
No. Here. Look at.
who are you
I'm for the petitioner.
petitioner Sham Mco
Yes. There are two matters. 36 and 37.
affidavit in service be kept in record filed by Mr. Banerjee the London Senior Counsel be kept in record adjourn to 10 February
Can it be earlier?
Earlier?
Then I'll just take a note today and come back tomorrow.
তাহলে অর্ডার কেটে দাও not today করে দাও so take it back
Yeah, I'll take it. That's best because I'm asking for an interim order for them not to proceed in the matter. And usually interim orders I'll show are granted this sort of.
not today you are not present Possibly I had to finish the other matters.
3637 nahi. We will come back, my lord, tomorrow.
কালকে কি আছে ম্যাটার? জাস্ট মিনিট, কালকে কি আছে?
Tomorrow is 24th.
এগুলো কালকে দেওয়া যাবে? দেখুন। এইটুকু দিয়ে দাও। এইটুকু।
I'm so grateful.